Hello and welcome. My name is Ali Goff. I'm the owner and founder of Goff Legal. We do estate planning, trust administration, and probate here in California. This video is called So You'd Like to Pay Your Lawyer a Lot of Money. No, I'm just kidding. Although that is part of the moral of the story, it's actually called So You'd Like to Name Joint Agents. Why we think you might want to reconsider. Sounds more professional, does it? The end result is still the same. So here's the deal. We get these questions a lot. We have a lot of conversations with a lot of wonderful families, and a lot of people consider or want to name co-trustees, co-agents, co-executors, meaning two people are serving together. Here's why that's not a great idea. Number one, administratively, it's a lot of work. Everything that one person is doing oftentimes requires the consent or the actual signature of the other person who's serving. So if you have co-trustees and you need to open an estate bank account, you both have to go to the bank to sign it. Not all banks are that way, but many are that way. Let's say you have a real estate transaction and you need to hire the agent. You both need to sign that. Then you need to sign the listing agreement. You both have to sign that. Then you have every time there's a signature, there's two signatures. So it will slow things down and it will take more time. Yes, you can delegate certain authority, but oftentimes institutions aren't going to care whether the document says one person can sign. They're going to go, don't care what your document says. We need two signatures. So that's number one. That's like the best case scenario. Administratively, it's a little more annoying and time consuming and just slows things down. But the reality is, if you name joint agents, there is so much room for disagreement and distrust and a lot of lawyer fees. Every agent under power of attorney or trustee, has the right to have an attorney. Great. That means they have the right to have their own attorney. So if they're disagreeing, the trust is now paying each of their lawyers to disagree with each other over something. That's a lot of lawyer fees. That could be double, triple, quadruple. Why? Because they're probably not getting along. It also doesn't allow people to make decisions. You've got a couple of people who want to make this decision, right? You've got the co-trustees who want to make this decision and everyone else who doesn't. Well, that's fine if they get along, but what if they don't? What if the co-trustees are the ones who don't agree? Now you've got two people in power who have decision-making authority, who could make a decision, who can't make a decision. And you know what happens? They hire litigators, they file a lawsuit, they're off into court, and all of the money is now going into the attorney's pockets, not to your trustee and not to your family. Hopefully they can resolve it quickly, but if not, there might be mediation, there might be a trial, they might be both removed because there's a probate code section that says if the co-trustees can't get along, they don't get to be trustees at all. Poof. Bad idea. Not fun. Not fun. Okay. But you're going to tell me, and I know this is what you're going to say. My family's different. They get along so well. And I'm here to tell you they might now, but they might not later. And what I want to leave you with is not that your kids are bad, not that your family are evil, or that they're going to be doing something funky. It's that death and money cause a lot of emotional complications, and people who got along previously might not get along later. Now, there are some benefits to having co-trustees. You've got a partner in crime to go through this process together. That can be wonderful. But I would never, ever put co-trustees both in place because you want them to know what's happening. That's not going to work out because they're going to fight with each other and they're still going to have misinformation going back and forth. So here's my tip. Don't name co-agents. Name people that you trust one at a time. Now, if you have a family situation that you think naming one child above the other is going to cause severe strife and actually ruin their relationship, my advice is to find another friend or family member, or better yet, a licensed professional fiduciary or a bank or trust company to serve in that role. That way, your kids can be your kids. They can grieve, they can go through the process, and they don't have to fight with each other around who's doing what with the property. They can sit back and relax and let a professional take the reins, do all of the legwork, and really get this thing done faster than your kids could, because why? They're professionals. So tip number one, Don't name co-trustees, co-agents. If you do, we'll do it, by the way, after advising you that we think it's a bad idea. Make sure you have some sort of dispute resolution language that says, if this happens, here's how we resolve these disputes. If one agent can't act, here's the backups. Oftentimes, planning costs more if you name joint agents because we have more work to do. We have to untangle the potential messes now before you're even gone. So I hope that was helpful, a little scary, and very useful. Because why? Because you should know this when you're planning an estate plan to not just sort of blindly move forward. You really should think about who you're putting in what place. With that, I wish you the best. If you want some more information, you can check out our website, gofflegal.com.